Hi, Stefano Molea here, San Diego criminal defense lawyer and partner at the law office of David P. Shapiro, where we help good people regain control of their future when charged with a crime. Today I want to talk to you a little bit about what a motion to suppress is and what the possible outcomes are at a motion to suppress hearing. All right, so a motion to suppress is sort of dictated, right, or codified in Penal Code Section 1538.5. And it outlines sort of the different bases in which you can file this motion. But the basic understanding of it is that you file a motion to suppress when you argue that law enforcement or a government actor violated your constitutional rights by either detaining you without reasonable suspicion or arresting you without probable cause. Right? Those are the basic ways in which you can assert that your constitutional rights were violated, right? Your Fourth Amendment rights were violated. So what happens at a motion to suppress hearing? Well, if there's not a warrant, then the prosecution has the burden of convincing a judge that there was in fact probable cause for an arrest or reasonable suspicion for a detention. And when that happens, they have to put on witnesses, which means that I get to cross-examine those witnesses and ask them questions that may open up things outside of just what's in their report. Now, at the end, the judge is going to apply, what the evidence is to what the law is and make a determination. If the judge grants the motion to suppress, the significance is that any evidence, and that can be statements, it can be test results, it can be observations, literally anything that comes after an illegal detention or an illegal arrest gets suppressed, meaning that the prosecution now can no longer use it in their case in chief. In other words, they can't use it to prosecute your client anymore. And that's going to be very, very important. And potentially, and as it has in some cases that I've litigated 1538.5s before, can result in them determining that they can't prove the case anymore, so the case gets dismissed. But look, sometimes you don't win suppression hearings, suppression motions. Sometimes you end up losing them, but you still get something valuable from the hearing. And a recent example was from a hearing where my client was charged with a driving under the influence type of offense. The issue was whether or not my client consumed alcohol after he stopped driving, which is a very legitimate issue. And then the question that I raised was, well, if there's evidence that there was alcohol consumed after he stopped driving, can law enforcement have probable cause that at the time that he was driving, which they don't know about because they found him stopped somewhere, was he impaired or under the influence, or would they be C.8 or more? And so my contention was they can't. But even though the judge disagreed with the ultimate sort of ruling of denying my motion, here's what did happen. One witness provided a key piece of evidence and testimony that was nowhere to be found in any of the reports, that now has opened up all kinds of different options for the defense and been able to fight this case all the way to trial and put us in a much better position of being able to assert a defense that can win at trial. So just wanted to give you kind of an overall big picture view of suppression hearings and what can come out of them. Even though sometimes you may lose them, there's still something good that can come out of them. Hope this information was helpful. If you have any questions, feel free to ask them in the comments or give us a call. Stefano Molea, San Diego criminal defense lawyer at the law office of David P. Shapiro, 619-295-3555.